Good morning and welcome. Today is Wednesday, November 30th, 2022, and this is a time and place for the hearing examiner's proceeding for docket number 2022-025, cause number 132-06. In the matter of the request for agency action of OVINTIV USA, Inc. for an order vacating the order entered in a cause number 139-99 and instead pooling all interests, including the compulsory pooling of the interests of certain non-consenting owners in the Nooh Tuh Vweep wells in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the Lower Green River-Wasatch Formation, comprised of all sections 16 and 21, Township 3 South, Range 2 West, Uinta Special Meridian, Duchesne County, Utah. My name is John Rogers. I'm Environmental Manager with the Utah Division of Oil, Gas, and Mining, and I've been appointed by the Board of Oil, Gas, and Mining as a hearing examiner in this matter. We are holding this hearing with an anchor position in Department of Natural Resources building in Salt Lake City, Utah. We'll also be hearing testimony and presentations in person and virtually, and the proceedings will be broadcast on the internet via YouTube. I wish to thank the division staff, legal counsel, petitioners, and the department technical staff for allowing this proceedings to go forth both remotely and in person. We'll take appearance of counsels at this time.
Fred McDonald of Counsel with Lear & Lear on behalf of Petitioner OVINTIV USA, Inc.
Trevor Guel with the Utah Attorney General's Office on behalf of the Division of Oil, Gas, and Mining.
My counsel is Elizabeth Harris of the Attorney General's Office. At this time, we'll proceed to Mr. McDonald for his presentation.
Thank you, Mr. Rogers. Testifying remotely today, thanks to the board's authorization of November 21st, are Mr. Peter Burns, Senior Land Negotiator. Peter, would you please wave so that they can identify you? And Mr. Kendall Brown, who's the manager of the Uinta Reservoir Engineering for OVINTIV. Kendall, thank you. I would ask that the witnesses be sworn in at this time.
Okay.
Will you raise your right hands, please? You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do. Thank you.
Gentlemen, if you could just move the mics a little bit closer so that we can hear you a little bit better. Thank you. Mr. Rogers, the resumes of both witnesses were collectively submitted as Exhibit A in this cause. If separately asked, each would verify the contents of their resumes are true and correct. Mr. Burns will be providing both factual and expert testimony. While he has testified before the board many times on factual matters, this will be the first time he is providing expert testimony, and we will qualify him as an expert in petroleum land management at the commencement of his testimony. Mr. Brown has previously been recognized by the board as an expert in reservoir engineering in cause numbers 13009 and 13010. Presuming the division has no objection, I ask that you recognize him as an expert in petroleum engineering for purposes of this cause.
The division has no objection for Mr. Brown and does not anticipate objecting once the other witness has been qualified as an expert.
Okay. Both of them will be recognized as expert witnesses at this time.
All right. Thank you, Mr. Rogers. I also want to confirm that it will be acceptable for me to move for admission of my exhibits at the end of our presentation in chief.
That'll be fine.
All right. Thank you. This cause involves the compulsory pooling of the drilling unit established for Lower Green River-Wasatch production, comprised of the entirety of sections 16 and 21 of Township 3 South, Range 2 West in Duchesne County. The drilling unit was established by the board's order entered on July 21st, 2015 in cause number 139-134. The 139-134 order partially vacated the board's order entered on May 9th, 2012 in cause number 13990, which created sectional drilling units for production from these formations. Pursuant to the 13990 order, one short lateral horizontal well and one vertical well were drilled upon the Section 21 drilling unit. By order entered on June 12, 2013 in cause number 139-99, the board compulsory pooled certain parties in the Section 21 drilling unit and declared them as non-consenting owners in the two wells, all is more fully outlined in the request for agency action that was filed. It's important to note that there is a second order entered under cause number 13999, which addressed compulsory pooling in other drilling units. As expressly stated in the request for agency action, OVINTIV is only seeking vacation of the 13999 order that pertains to Section 21 drilling unit. True and correct copies of the relevant 13999 and 139-134 orders were submitted as Exhibit B in this cause. The 139-134 order also required Newfield, which is now OVINTIV, to seek modification of the 13999 order to waive further recoupment thereunder and to deem full revision once a long lateral horizontal well was drilled and produces from the Section 16 and 21 drilling unit established by that 139-134 order. Thereafter, a short lateral horizontal well was drilled on the Section 16 drilling unit in accordance with the 13990 order, which began production in 2018. There are no non-consents as interests were carried by OVINTIV, and no remaining recoupment pertains to that well. In accordance with the 139-134 order and the APDs approved by the Division and the Bureau of Indian Affairs, OVINTIV drilled the 8 Nooh Tuh Vweep wells described in the request for agency action, to which I will refer to as the NTV wells for purposes of pronunciation as well, as OVINTIV's first attempt at cube development. This is concurrent drilling and completion. Mr. Brown will address cube development and the associated risks in his testimony. The first NTV well's date of first production was November 20th, 2020, resulting in the conversion of the Section 16 and Section 21 drilling units and the required modification of the 13999 order effective as of December 1st, 2020. However, all the parties specifically compulsory pooled under the 13999 order or the successors have since leased or have executed joint operating agreements covering the Section 16 and 21 drilling unit. Consequently, the 13999 order should be vacated in its entirety. Andrew K. Stein is the owner of an undivided 2.25% oil and gas interest in the northeast quarter of Section 16, which equates to a 0.28125% working interest in the Section 16 and 21 drilling unit. As the record will reflect, good faith efforts have been made to locate Mr. Stein, but to no avail. Pursuant to the board's order entered on October 14th, 2022, a notice of opportunity to participate to Mr. Stein relating to the 8 NTV wells, as required on Utah Administrative Code R641-2-9A, was published in the Uinta Basin Standard for 2 consecutive weeks, but he has not responded to that notice or has otherwise tendered his share of costs for the wells. Consequently, OVINTIV seeks the compulsory pooling of his interest and to declare him as a non-consenting owner in the NTV wells. Finally, some of the fee leases were granted by parties claiming by, through, and under the estates of certain deceased parties as identified in the request for agency action, for whom no confirmatory Utah probate proceedings have been initiated, or if initiated, are incomplete as to proper distribution to the heirs or devisees. As such, there is the possibility of some unknown party claiming by, through, or under these estates who is unleased and not pooled. Consequently, as to such potential unknown heirs or successors, pursuant to the same October 14th, 2022 order from the board, notice of the opportunity to participate was published in the Uinta Basin Standard for 2 consecutive weeks. No party has responded to that notice or otherwise tendered his or her share of the cost for the wells. OVINTIV therefore seeks to have these unknown parties to be compulsory pooled and also declared as non-consenting owners. The proof of publication to Mr. Stein and the unknown heirs or successors was submitted as substitute Exhibit F in this cause. As to the non-consenting parties, OVINTIV seeks imposition of a 300% risk compensation award and the terms of a joint operating agreement materially the same as signed by the other working interest owners in the drilling unit at issue, and which terms have been previously deemed just and reasonable by the board in other compulsory pooling hearings. During the recoupment period, the unleased non-consenting owners will be entitled to a 16.444643% cost-free royalty, representing the average weighted fee royalty in the drilling unit calculated as of the date of spud of the first NTV well. The board has jurisdiction, or the hearing examiner through the delegation of the board has jurisdiction over this matter pursuant to Utah Code Annotated Sections 40-6-6.5 and the implementing regulations, which are R649-2-8A and R649-2-9A. And as I mentioned, this was delegated to you as a hearing examiner by the board's order on October 14th, 2022, pursuant to Rule 641-113-100. A copy of the request for agency action was mailed regular mail to all the production interest owners within the drilling unit at their last addresses disclosed by the relevant realty records, and to the Ute Tribe, Ute Distribution Corporation, and the Bureau of Indian Affairs due to the tribal and allotted mineral ownership within the drilling unit. In addition to the published notice of opportunity to participate I previously mentioned, notice of the filing of the request for agency action in this hearing was also duly published in the Uinta Basin Standard on November 2nd, 2022, the Deseret News on November 4th, 2022, and in the Salt Lake Tribune on November 6th, 2022. The division filed a response on November 15th, 2022, not objecting to the request for agency action, but simply pointing out the legal precedent and applicable regulations concerning how the risk compensation award requested should be determined by you, Mr. Hearing Examiner. No other objections or responses to the request were filed. And as none of the alleged consenting parties filed a timely response to the request, pursuant to Utah Administrative Code Rule R641-104-150 and R641-108-400, OVINTIV moves to enter an order of default against them in this cause. I don't know if you want to rule on that motion at this point, just for the record, or not.
Yes, we'll rule on that and accept that as a default order from this.
Thank you, Mr. Examiner. With that, I'm going to commence my examination of Mr. Burns. Mr. Burns, would you please state your name and business address for the record?
Yes. Peter Burns, and OVINTIV's address is 4 Waterway Square Place, Suite 100, The Woodlands, Texas, 77380.
And what's your current position with OVINTIV?
I am a senior land negotiator with responsibility over this drilling unit, among others, within the Uinta Basin.
All right, would you please provide to the hearing examiner a brief summary of your education and your work experience, particularly in the Uinta Basin and as relevant to this particular cause with joint operating agreement preparation and negotiation?
Yes, I have a bachelor's degree in history from DePauw University in Greencastle, Indiana, and a master's degree in business administration from the University of Colorado. I've worked in the oil and gas industry for 14 years, 8 of which have been here in the Uinta Basin. During those 8 years, I've negotiated and prepared dozens of JOAs across OVINTIV's acreage position.
Mr. Hearing Examiner, with that testimony and his resume, again, I just want to confirm that he's being recognized as an expert in petroleum land management for purposes of this cause.
No objection from the division.
We'll accept him as an expert in this case.
Thank you. For the record, Mr. Burns, would you please state the corporate and bonding status of OVINTIV?
Yes. OVINTIV is a Delaware corporation in good standing with its principal place of business for Rockies operations in the Woodlands, Texas. It is duly authorized to conduct business in Utah and is fully bonded with all appropriate federal and state agencies. It is the successor by name change to New Fuel Production Company and by merger of OVINTIV Production, Inc.
Mr. Burns, I'm now going to direct your attention to what have been marked as Exhibits C, D, and E for purposes of this cause. Do you recognize these exhibits?
Yes.
Were they prepared by you or OVINTIV personnel with your input and review?
Yes.
Turning your attention to what has been marked as Exhibit C, which is shown on the PowerPoint here in the hearing examiner's room, would you please explain to the hearing examiner and the division what this shows?
Yes, this is a regional locator map of the subject DSU outlined in red. Sections 16 and 21 are located nearly 2 miles due west of the Mighton town site and 1.5 miles north of US 40 in Duchesne County.
Turning your attention now to what has been marked as Exhibit D, would you please explain what this shows?
Yes, this is a plat of the oil and gas ownership within the subject DSU. This shows the 15 different oil and gas tracts. OVINTIV is the majority lessee working interest owner in the DSU and is the operator of the NTV wells. Tracks 1 and 14 are tribal oil and gas minerals. Tracks 7, 11, and 90.91% of Track 12 are allotted Indian oil and gas leases. And as provided in the compulsory pooling statute, royalty under those tribal leases are not included in the calculation of the average weighted landowner's royalty applicable to the unleased non-consenting owners. The remaining tracts within this DSU are owned in fee. Andrew K. Stein owns a 2.25% unleased oil and gas interest in Tract 13, which translates to a 0.28125% working in the drilling unit. As Mr. McDonald mentioned, several lessors claim title in various fee tracts through one or more of the estates of the following deceased record mineral interest owners. And I will read these off here. Abe Stein, Eleanor Stein, Hugh H. Fowler, Nancy Fowler, Cora J. Hawkswood, Doris V. White, Elgene S. Lowe, Elizabeth Felter, Irma Scholes, Faye B. Higginson, Francis Sam, a.k.a. Helen Sam, a.k.a. Helen Francis Attiker Sam, Jerry N. Mascarenas, John Clyde Hawkswood, Joseph Sam, Marianne Felter Jensen, Marianne Felter, Mary Levon Young, Ray C. Scholes, Richard Douglas Worsley, Vera Larson, and Victor W. Waite. Either no Utah probate of the estates has been initiated, or if it has and has been filed, they're incomplete, and that there's been no proper distribution made to the heirs or devisees. Although based on heirship affidavits and other inquiries and research done by OVINTIV's lease broker, OVINTIV believes it has leased all of the successors. However, without an order from a Utah court confirming their succession, the possibility exists that unknown successors may successfully establish succession. Such owners would be unleased, and therefore OVINTIV seeks to compulsory pool their interests. OVINTIV has executed and recorded a pooling declaration pooling its fee leases in the drilling unit pursuant to authorization contained in the pooling clause of said leases, and is in the process of filing a communitization agreement to communitize the Indian leases with the fee leases. In addition, as Mr. McDonald mentioned, certain of the parties compulsory pooled under the 139-99 order are unleased working interest owners who have since also executed joint operating agreements reflecting their voluntary pooling in the drilling unit.
Now, turning your attention to what has been marked as Exhibit E, would you please explain to the hearing examiner and the division what this reflects?
Yes, this is a plat of the NTV wellbore path locations. This generally shows the location of the 8 NTV wells in the subject DSU, sections 16 and 21. All 8 NTV wells were spud in mid to late December 2019, early January 2020, and all were completed and began production in November 2020 as outlined in the RAA. These wells constituted OVINTIV's first attempt at cube development, which Mr. Brown will address in more detail. Consequently, conversion of the existing wells to the Section 16 and 21 drilling unit occurred effective December 1st, 2020, per the 139-134 order.
Mr. Rogers, Exhibit F was the proof of publication of the Notice of Opportunity to Participate as submitted by the Uinta Basin Standard. Mr. Burns, referring to that notice, did you ever receive any responses from anybody in relation to that published notice?
I did not.
All right, now I'm going to have you turn your attention to Exhibit G, which was also submitted as Exhibit 1 to the request for agency action. I do not have that on a PowerPoint in full, only certain portions of it, which we will highlight. Was this joint operating agreement prepared by you?
Yes.
All right, would you please explain a little bit about that exhibit?
Yes, this JOA is a form, standard form used within the industry. It is supplied by the American Association of Professional Landmen. This particular form is Form 610. This is the 1989 version, which has been modified to address horizontal wells. The terms and conditions contained herein, including the modifications made, are consistent with other JOAs executed by other working interest owners in this particular drilling unit and are commonly found in more recently developed horizontal well drilling units. OVINTIV has prepared identical terms for other drilling units it has operated and has agreed to such terms in other drilling units in which it is a non-operator, including drilling units operated by Uinta EP Energy, now Javelin, and other major Uinta Basin operators.
All right, Mr. Bernas, I'm going to turn your attention to a portion of Exhibit G that's highlighted here. Do you see that on the PowerPoint?
Yes.
This is page 7 of the joint operating agreement. Would you please address what the highlighted portions are?
Yes, this highlighted portion addresses the non-consent penalty, and in this particular one, we are asking for a 100%, 300% non-consent penalty, which is the same as contained in the JOAs signed by other working interest owners in this drilling unit and is standard among other non-operators in the Uinta Basin.
All right, now turning your attention, this is Exhibit C to that joint operating agreement. This is on page C3. Again, would you please address what Exhibit C to the joint operating agreement is and what this highlighted provision shows?
Yes, Exhibit C to the JOA is the COPUS provision outlining accounting procedures. Again, this is an industry standard form, almost universally utilized, similar to other JOAs in the Uinta Basin. Page 3, Article 3B, sets the interest rate at the prime rate published in the Wall Street Journal plus 3%, which is fair compensation and to encourage timely payment of chargeable costs and expenses.
Okay, now turning to page 9 of that same Exhibit C and the highlighted provision shown on the PowerPoint. Please explain what those are.
Page 9 in this particular highlighted section outlines the overhead charges, which in this case are $10,000 per month for the drilling rate and $1,000 per month for the producing well rate.
All right, Mr. Burns, in your expert opinion then, are the terms and conditions of the proposed joint operating agreement fair and reasonable and consistent with those accepted by other working interest owners in this drilling unit and with those commonly accepted by industry and in particular the Uinta Basin with respect to horizontal well operations?
Yes.
All right, Mr. Rogers, just to point out again, Utah Code Annotated Section 40-6-6.5, subparagraphs 6 and 8 provide a compulsory pooled unleased owner is entitled to payment of the average weighted fee royalty during the payout period. That does not include federal, state, or Indian royalty. Mr. Burns, I'm now going to turn your attention to what has been marked as Exhibit H. This is actually a 4-page exhibit. Do you recognize this exhibit?
Yes.
Was it prepared by you or OVINTIV personnel with your review and input?
Yes.
All right, I'm just going to turn to the last page, which is the most important. Please outline to the hearing examiner in the division what this shows.
Yes, this exhibit reflects the calculation of the average weighted fee landowner's royalty for the Section 16 and 21 drilling unit as of the date of spud of the first NTV well. This average weighted fee royalty is 16.444643%. This includes royalty provided in lease forms attached as an exhibit to the JOAs signed by the unleased working interest owners in the drilling unit.
All right. There are, as pointed out in the request for agency action, there were some existing wells within Section 16 and 21 before these horizontal wells, these long lateral horizontal wells are well. Would you please outline what is the treatment of those and how will they be treated if this compulsory pooling request is granted?
The Thorn 4-21, 3-2-16-7H well is a short lateral horizontal well drilled in 2018 in Section 16 after the 139-99 order. OVINTIV decided to carry unleased owners to 100% payout and then net them out. As noted with the spacing conversion, Any remaining recoupment was waived effective as of December 1st, 2020. This results in the dilution of working interest owners in the specific existing well in their section, but they now receive production from the existing well on the other section, bearing only go-forward operating costs.
All right, would you also confirm for the record all the other land-related allegations of the request for agency action?
Yes.
All right. I'm going to now direct your attention to the certificate and supplemental certificates of mailing. These were pleadings prepared by my office. They're already on file in this cause. Do you have those in front of you?
Yes, I do.
All right, and can you tell us who are the persons shown on that list, and how were they determined in the addresses that are shown there?
These are the people who all have a production interest within Section 16 and 21. The addresses were derived from two title opinions effective as of September 27th, 2019, and as updated by a search of the county records by Lone Wolf Energy, our land broker in the Uinta Basin.
Is it also based on your internal records?
Yes.
All right. Mr. Hearing Examiner, there's no Exhibit Z, which we normally file, which would be return receipts. Because of the number of parties here, we just send them out regular mails, just so that you know that there is no exhibit to that effect. With that concludes my examination of Mr. Burns.
Okay. Division? Any questions for this witness?
Yeah, just a small point of clarification on this exhibit H-4, the participation factor lease net acres by total leased fee net acres. Should that be divided by total leased fee acres?
Yes, I actually noticed that this morning. It should be lease net acres divided by the total leased fee net acres.
But the calculations were done correctly. It was just a clerical mistake on the exhibit. Is that correct?
That's right, yes.
Okay, with that clarification, did you have any? With that clarification, I think the division is totally good with this witness.
Okay, thank you. I have a few questions I'd like to address at this time. Just for clarification, the 139-99 order back in, 2012 was it?
13.
13? That was a forced pulling for, and I know we talked about this, 2 and 8 and 1 west and 21 and 2 west. Now, how is that going to affect here?
Okay, again, there was 2 orders entered by the board. Okay, there was one earlier, I believe it was in January, that dealt with sections 2 and 8 alone.
Okay.
And section 21 was not included in that order. The one in June, which is the one that we're asking to be vacated, strictly deals with compulsory pooling of section 21.
Only 21?
Yes.
Okay. Now back to section 21. There are some existing wells there. I know Mr. Burns explained what would happen. Were any of those wells forced pulled under that order?
Yes, there was 2 wells that were identified in the 139.99 order. There was one vertical well and one short lateral horizontal well in section 21. Okay, and then as Mr. Burns testified, there was a subsequent well drilled in 2018 in section 16 that was not compulsory pooled.
That didn't have an order for that?
No, OVINTIV made the decision to just carry the working interest owners and then net them out after 100% payout. That was his testimony.
So explain to me what happens to those forced pool wells in section 21. And you went over that. I just want to get that clear in my mind.
Well, at this point, there's no more recoupment on it. They're not considered non-consent, so they're on a go-forward basis on the horizontal wells. And I believe, Mr. Burns, correct me if I'm wrong, that most of the parties that were compulsory pooled under that order have either since leased or signed joint operating agreements. Is that correct?
That's correct, yes.
Yeah.
So they have made that determination that there's no risk to them, or they feel comfortable with this?
Correct.
Could we go to Exhibit E? Oh, back one. Okay, I'm a little confused about this diagram. Are these surface locations and terminus, or what are these and which is which? They're both just red dots. I can't make any sense of which is which here.
The red dots are really just to show the end points of each lateral, each wellbore path.
Oh, okay, so they got 2 red dots. So which is the terminal side and which is the surface?
I believe all of these wells were drilled north to south.
Okay.
And there were two surface locations, one in the northwest, I think it was actually the southwest of Section 9 to the north, and then the far northeast corner of Section 16.
So this strictly tracks the horizontal portion, and these surface locations were off lease? Okay.
Yeah, I did not put the surface locations on here. This is really just to show the productive interval of the wellbore.
And it's north to south?
Correct.
Okay.
Yes.
That's all I had. Next witness.
All right, thank you. I'll commence my examination of Mr. Brown. Mr. Brown, please state your name and address for the record.
My name is Kendall Brown. The address I work at is 4 Waterway Place, Suite 100 in the Woodlands, Texas, at OVINTIV's office.
All right, what is your current position with OVINTIV?
Currently, I'm the manager of our Uinta Reservoir Engineering Group.
All right, I'm going to direct your attention to what have been marked as Exhibits I and J. I only have Exhibit J as a PowerPoint. Do you have Exhibit I in front of you as well?
Yes.
All right, and were those prepared by you with your review, or OVINTIV personnel with your review?
Yes.
All right, please explain what Exhibit I collectively are.
Exhibit I is the AFEs at the time of prior to drilling that OVINTIV had put together for estimating the cost of drilling and completing and putting onto production the NTV wells.
All right, now turning your attention to Exhibit J, this is an 8-page exhibit shown on the PowerPoint. Explain what this shows.
So Exhibit J shows up to the prior month's total costs incurred by OVINTIV on a gross cost of the drilling, completions, and production of those wells, and it's split out by well. So that's the total cost that's incurred on a gross basis for each well.
And how do the actual costs shown on Exhibit J relate to your estimated costs shown on Exhibit I for these wells?
The costs are reasonable within the expectations we set out for the first cube development in the AFEs. There's not a significant variation that we've experienced here.
All right, in your expert opinion then, were the costs fairly and reasonably and necessary incurred?
Yes.
And were they also deemed, quote, economically feasible, as that term is used in the 139-134 order to drill?
Yes.
All right, would you please address for the record, what is the estimated plugging and abandonment cost for the 8 NTV wells?
Our current cost estimate is $75,000 per well to plug and abandon the NTV wells, based on 100% ownership.
So each well at $75,000, is that correct?
That's correct.
All right, turning your attention now to Exhibits K and L. Were these prepared by you or by OVINTIV personnel with your review and input?
Yes.
All right, turning your attention to Exhibit K, there's a lot of information on here. Would you please explain what this shows?
So the main purpose of Exhibit K is to show the existing wells that surrounded the NTV development prior to spudding those locations. The key takeaway I want to have from this exhibit is, although there is a handful of 10,000-foot horizontal wells surrounding this unit, there had never been a full unit drilled in a cube style that OVINTIV has done. That really means we're trying to develop all of the horizontal formations together to reduce our surface footprint, as well as increase some efficiencies, but it does increase the amount of capital spending in a small area, which increases our risk when we put a lot of capital into one small area. We did drill all 4 formations shown on this map, the Upper Castle Peak, Uteland Butte, Upper Wasatch, and Middle Wasatch, all together in this existing unit at 8 wells, in addition to the existing 2 horizontals and additional verticals in that well, being the densest development that OVINTIV had ever drilled at the time.
Okay, so again, you kind of gave a brief summary of cube development. Would you just reiterate that for the record and for the hearing examiner in the division?
Absolutely. OVINTIV uses the term cube development, and what we really mean by that is we want to have numerous wells on a singular surface pad to reduce our surface impact to the lands, as well as be able to develop both vertically and horizontally all of the primary target formations that we think are economically feasible. And that's exactly what we did in this particular unit.
Turning your attention now to Exhibit L, would you please explain the risks that were involved with these wells in relation for determination of the appropriate risk compensation award?
Yeah, so the first risk being, like I mentioned previously, targeting all four formations stacked together is really on the density impacts of there being the potential for these wells to interact with each other with our hydraulic fractures. The other primary risk is on any depletionary effects we may see from the vertical wells or existing horizontal wells within the units. Those could have potential impacts to the production of the wells. On the actual drilling side, all four formations, the Upper Castle Peak, Uteland Butte, Upper Wasatch, and Middle Wasatch, tend to have a high clay content in them, which poses a drilling hazard primarily for hole stability, which would cause us to lose stability in the laterals while we're drilling, which can cause the hole to collapse, which would require additional spin and sidetracking. And as shown there on the NTV 24H, that did happen to us. We did lose the lateral drilling that well and had to sidetrack and add additional spin on that well.
All right, in your expert opinion then, for those reasons, do you believe a 300% risk assessment award is justified for this particular drilling unit, these wells?
I do.
All right.
Yes.
Would you also confirm for the record all the other engineering allegations of the request for agency action?
Yes.
All right, Mr. Rogers, that concludes my examination of Mr. Brown.
Okay. Division, do you have questions for Mr. Brown?
No, we don't.
Okay. I got a few questions at this time. First of all, we talked about the plug-in and abandonment cost of $75,000 per well. How is that calculated? Is that an actual or just kind of what you've seen in other areas? Can you kind of explain to me how that number comes about?
Absolutely. So we have a fairly active plug and abandon program across the Uinta Basin. It's primarily plugging and abandoning our older vertical wells. So $75,000 is really kind of an average estimate based on what we've seen our plugging and abandonment costs be on the wells we've been P&Aing every year.
So since that is a vertical wells you're looking at, is there any difference when you're plugging a horizontal well or additional costs?
There's not a significant difference in the plugging costs. There's no P&A work we have to do additionally with the horizontal. All the plugging work is done in the vertical portion. So there's really not much additional cost there.
And does that include surface reclamation too? That number?
This does include surface reclamation. That is one piece where the cost can vary a bit. Just so you understand, is on large surface pads, that surface reclamation could be a bit more expensive, but $75,000 is about the average we see. So that is kind of diluted per well. Each well pays a little bit of that surface reclamation, but this particular development has 4 wells per location, so each well is taking kind of a fourth of the reclamation in there.
Okay, thank you. Could we go to exhibit, we're on it right there, L. The term on the first one, potential to connect production from well to well and overcapitalize the frac job. I'm assuming that means if you might have communication between the 2 frac jobs, or can you explain to me what that risk is there?
Yeah, so with these particular wells, we drilled the 4 formations like I mentioned. These wells are stacked essentially vertically on top of each other. So there is the potential to, and what we mean by overcapitalize is with the completions design that we pumped on these, we didn't know at the time of how large of a completion to pump on these wells. So what could happen is when we have these stacked and they're quite close to each other, that those fracks and ultimately the drainage from the elliptical drainage we get from those fractures could overlap with each other, which would cause a negative impacts to the production of our wells when we stack them together like this.
So as you're moving forward, are you getting a better handle on how to perform that frac so you don't have that happen, or is that something that's going to be ongoing?
That is definitely an ongoing challenge for OVINTIV and our peers in the basin as well. But it's definitely something we're learning as we're drilling more in this basin.
Okay, thank you. Continue down there. You talk about the clay intervals in each formation here. Now, are we talking, I'm a geologist, so that's my thinking. So are you talking the vertical or the change in the facies as you go lateral?
The change in facies as we drill laterally is the primary risk there.
Okay, so it's not in the vertical hole. You're seeing as you go laterally that you could run into clay portions or higher clay portions above and below the drilling of the horizontal that could cause collapse?
Exactly. As we're drilling these 2-mile-long horizontal wells, steering those is, there is generally, we would say probably 20, 30-foot windows we'd like to stay in, but that's always not achievable as the control you have is limited and how far you can see in front of the bit is extremely limited. So if you get exactly out of the target window you'd like to, you can run into some clay intervals that cause instability issues drilling the horizontal portion. We try our best to stay out of those, but that's not always possible.
Do some formations have more of that than others, or are you getting a feel for that?
Yes, I would say we've had more challenges in the Middle Wasatch than other formations, but they all pose this challenge to varying degrees. Each one, Castle Peak, I would say, and the Middle Wasatch are the more challenging. And the Castle Peak, we did have that issue. The NTV 24H is the Upper Castle, or sorry, I misspoke there. That's the Middle Wasatch well. That has been the bigger challenge for us.
Okay. Well, thank you. That's all the questions I have.
Mr. Rogers, that concludes our presentation to Chief. At this time, I would move for admission of Exhibits A through L inclusive.
Okay, so accepted. Division. Do you have
No objection from the division.
All right. With that, I'll just reserve closing remarks after the division makes its statement.
Okay, thank you. The division?
As outlined in the division's response that was filed, the division does not object to anything being requested by OVINTIV at this time. And having been here for the presentation in chief, the division is supportive of OVINTIV's request and thanks OVINTIV for their time as well as their investment in our basin.
Okay, thank you. Fred, we'll turn back over for summation then.
Yes, thank you, Mr. Rogers. I believe, all these statutory and regulatory requirements for approval of the request for agency action have been met. We believe that it's fair and justified, the 300% risk assessment award. We've met all the requirements, and we would ask that you accept that and make the recommendation to the board to grant the request as submitted. We also thank you very much for your time and council's time in allowing for this hearing examination this week, and especially to the IT group here at the division for their help too.
Okay.
Thank you.
Appreciate them. I'd like to take a few minutes to deliberate with my counsel, so if we could go off record and
order, you have to have the evidence on the record, and so I think that's why we go through the whole testimony part. And no one listens to the testimony. It's very dry, and I feel like it could be done as affidavits.
But before I start doing these, they'd all come before the board, and sometimes you have 2 or 3 in a day, and they can go on. And if they have questions, that's 6 hours.
I know, they're long and painful.
Plus everybody else is going on the board, so that's why the board likes to have so much to it, so not a big deal.
You should just do this all the time.
After deliberation, I feel so inclined to accept this order as written. And Mr. McDonald, would you prepare the order as we have done in the past and for our review and for the division to look at?
Certainly, I'll get that to you in the next 2 days or so, since
then
the
we'll-
hearing's next week.
Present that to the board at the next hearing.
Yes. Thank you very much.
Well, thank you. Anyone have any issues? Okay. Well, thank you for everyone involved with this. We appreciate the time, and thank you.
Thank you very much.
Thank you.
Thank you.
No,